Okay, we're good. William Beaumont Hospital versus Shaquille Anwar. Go ahead, Mr. Safarsky.
Good morning, Your Honor. We had a chance to talk, Mr. Anwar and I. We have agreed to a resolution. I'm going to be emailing him the proposal today or tomorrow morning. We should be able to have a signed agreed entry before the court within 2 weeks.
Is that correct, Mr. Anwar?
Yes, it is.
All right, perfect. I'll make a notation of that and we'll look for it. All right.
Thank you, Judge.
Thank you
Have a good
very
day.
much. Yep. Have a great day. Thank you.
Thank you.
Good morning, Ms. Roper. I have you checked in. As soon as we get the attorney back, she's in another courtroom with Zoom with another judge right now. And as soon as we get her back, we'll do your case, okay? Ms. Dixit, what case are you on?
Good afternoon. I'm here for case 211183 GC. I'm here on behalf of Westlake Services versus Tara Tucker.
All right, I have you checked in. We're just waiting on Mr. Evanchak.
Thank you.
And Ms. Roper, can you hear me? Ms. Roper, you got to unmute yourself.
I'm sorry, I can hardly
You got
hear
it. No, you're good. The attorney is in another courtroom right now. And so as soon as she jumps on, we'll do your case, okay?
Okay, thank you.
You're welcome.
Sorry about that.
Oh, no worries. You're fine.
Bye-bye.
And Mr. Sparks, did you have an opportunity to talk to Mr. Huziak?
Yes, we did. He couldn't figure out the breakout room and how to leave. We didn't reach a settlement, but I'm going to send him the statements that we have and we can discuss later further once he reviews them.
Let me go ahead and close this out so that we can get him back.
Thank you.
And there he is. All right, Mr. Huziak, my understanding is we're going to do an adjournment on this so that he can send you the paperwork. Is that correct?
That's
Yeah,
correct.
he provided me his email address and I just emailed him the statements. He just wants to take a couple days to review them. If we could either adjourn it or set discovery, whatever's easiest for the court.
I'll just adjourn it out to my June date, which is
Okay.
going to be June the 15th at 10:45. Mr. Huziak, it's going to be right in the same place on June the 15th, okay?
Okay, thank you.
And we'll make it at 10:45. And so if you join then, unless you guys resolve it, if you resolve it between now and then you won't have to, if you reach back out to Mr. Sparks, okay?
Thank you.
Okay,
Thank you, Your Honor.
perfect. All right, you're all set. Have a great day.
You as well. Thank you, Mr. Huzier.
Thank you.
Good morning. Can you not hear me?
Good morning, Miss Moody. What case are you on?
Case number is 204911. I'm sorry, I don't know how to cut my camera back on. Oh,
That's
wait.
okay. Last name's Hill, Chandra Hill.
Yes.
We're waiting on an attorney from Jefferson Capital, so as soon as they jump on, we'll do your case, okay?
All right, thank you.
So just hang out, yep. And you can go ahead and mute yourself.
All right.
All right, Ms. Nonis, we have Ms. Roper with us on ADLP versus Lucretia Roper, excuse me. This is an objection to garnishment filed by the defendant. I have the plaintiff's response. Did we lose her? I had Miss Roper. I think I lost her. All right, well, let's wait for a few minutes and see if she jumps on again. Sorry about that.
It's okay.
Mr. Landman, I'm gonna go out and call your case. Huron Estates versus Jamie Lee Floor. For the record,
Your Honor, Daniel Landman, P35797 on behalf of the plaintiff. Your Honor, this is a motion to permit execution of an order of eviction that was actually issued in February by this court.
I see that. I see that
More
the
than
writ was
56
issued in
days have
February.
elapsed. It cannot be carried out without providing the tenant notice and an opportunity to appear, which we did. And it's now 10:57. The case was scheduled roughly a half hour ago and no tenant has appeared. With that in mind, we would respectfully request that an order be entered granting the motion and permitting the order of eviction that was previously.
And I
entered by-
actually had that this back in November, there was a default as to defendant 1 and a consent as to defendant 2. November 6th of 2020.
I'm checking to see if I have a copy of the judgment. It does not bear the signature of Ms. Green, but I have a notation.
Well, it would have
that-
been as to the consent, it was on Zoom, so it was
was on
consented
Zoom.
to by Zoom. Yep, I have it. And the judgment actually says a default as to defendant 1 and
Yes,
as a consent as to defendant 2. So I'm gonna grant your motion today and you can submit that and I'll sign it.
we will submit an order, Your Honor. Thank you.
Okay, perfect. All right, thank you very much. We have Mr. Evanchek joining us on the Westlake Services case. Good morning, Mr. Evanchek. How are you?
Good, Your Honor. How about you?
Good. We, on Westlake Services versus Tara Tucker, I have Ms. Dixit here. Is that right? You're muted.
I'm sorry.
You're on this case, correct?
Yes, yes, Your
Okay,
Honor.
That's what I thought. This is set for a pretrial today. Do you guys need a breakout room?
No, Your Honor. I don't remember if I talked to somebody at Shermetta about this when I first got it, but there's gap coverage that doesn't look like paid. It's basically a car that got into a car accident. Insurance paid most of it. There's a gap claim. My client had gap insurance. The gap insurance got the claim, but it doesn't look like they ever paid out. And I feel like when I spoke to somebody at Shermetta, they were going to look into see if it had got paid. And then my client, I think we got her signals crossed, but she was supposed to follow up with the gap people, and I don't think she did that. So I think probably just give us some, if you could, just give us 90 days discovery, and hopefully we can get this resolved. If there is a balance, it should be small.
August 23rd at 10 o'clock.
That's fine.
Yes, Your Honor, that's fine.
All right, that's your date, August the 23rd at 10.
Thank you, Your Honor.
Thank you.
All
Your
right,
Honor.
thanks. Have a great day.
Yep.
You too. Thank you.
Miss Roper, can you hear me?
Yes.
All right, I have the attorney, Miss Nonis, on here. Miss Nonis, do you, Miss Roper, this was an objection to a garnishment. The plaintiff has filed a response that you have to have an exemption, like if it's social security proceedings or if it's social security or other reasons for an exemption, we don't have anything filed to that. Is there, do you have evidence that that's?
Yeah, I have the Michigan Social Welfare Act, the MCL 400.63.
Why don't I put you in a breakout room with Miss Nonis and you can talk to her and show her whatever you've got, okay?
Okay.
Oh, you're gonna have to be able to use your screen though to be able to show her.
Okay.
Go ahead and hit join.
Join. Oh, start. Okay.
And Miss Streichertz, what case are you on?
Hi, Judge. I'm back this time on Jefferson Capital v.
Got it. And I
Hill.
have Miss Hill on here.
Oh, great. Can we go in a breakout room?
Jefferson. Yeah. Miss Hill, can you hear me?
Yes, I hear you.
I'm gonna put you in breakout room number 3. If you go ahead and hit join, and the attorney will meet you there.
All right.
Go ahead and hit join. Miss White, I have you checked in. As soon as the attorney in your case appears, I'll call your case, okay?
Okay.
Thank you.
Thank you.
Mr. Brainer, are you here on Discover Bank versus Terry Shona?
Yes, ma'am.
All right, we're just waiting for the defendant.
Okay, thank you.
All right, so we got you back.
Sorry about that. Thank you. This thing is new to me.
No worries. ADLP versus Lucretia Roper. Ms. Nonia, did you have an opportunity to speak to her?
Yes, Your Honor. So I tried to explain as best as I could the situation, and we went back from the tax garnishment to now to advise the court. She was questioning the balance because the tax garnishment at the time of filing in October of 2020 had a balance of 49 and some change, so 4,900 and some change. She didn't understand why then in March, bank garnishment had a balance of the 53.55 cents. So I advised that when the tax garnishment is filed, it's for whatever balance is at the time, and there's accruing interest of 13%. So we walked through that. I confirmed that we did receive for tax garnishment funds in the amount of 190, which was applied. So when we received the bank garnishment funds, there is an overpayment. So the overpayment check actually was returned on the 13th of May, which she confirmed she received.
Okay.
So she received the overpayment back, and then we're closing out the interest paid in full. So after I think we're on the same page of what transpired and why we are where we are.
Okay.
Did ask for a paid in full letter, which I will get to her. And then she also requested the credit report situation. So I will make sure that my client does what it's supposed to remove that from her credit, which could take up to 6 days.
And we
Perfect.
are not on the same page actually, because I still can't understand far as like with them saying that they sent letters to me about my credit report and it has the wrong address. The only thing I received was from my bank, and that was actually, it has Colbury on it, not even my address. And then two, I thought that with the pandemic
The
page,
Colbert, that's the address we have too on the file.
right, it's 15057 Colbert with a
Colbert,
T.
yep.
Right. And with our mail and stuff, like our mail lady is not I want to say doesn't really pay attention to far as if it's like when the information is wrong, because I have the mail coming from my neighbors. I actually received their check from my neighbor the other day. So
Oh, okay, but you did get it back. Yeah, I mean, the thing is the garnishment is that we mailed out has your right address.
it doesn't.
And you objected to the garnishment after they did it. Yeah, I mean, it's for notice. I understand what you're saying. When they sent the garnishy disclosure that I see that it has Colbury instead of Colbert, that's not a reason that we can set it aside today. Like I said, if you had a like an issue that you, oh geez, sorry about that. I'm trying to let somebody in.
Yep. It's me.
Far as
Okay. So what I'm gonna do is they're gonna deal with your credit report. I am gonna deny your motion and they'll close this file out and send you the credit report, okay?
it's not okay, because I feel like with the pandemic, we were released money for a reason. And at the end of the day, we are on our knuckles. And I've been working through this pandemic and trying to get myself together
And
with my credit.
And if
And
I could change the law, I would, but they didn't exclude, I mean, the exclusions were not related to returns. They can garnish your bank account for money that you owe unless it's Social Security, disability, those types of things.
So what's the Social Welfare Act?
I can't give you legal advice. If you think that they did something wrong that should have been part of the objection, then you need to file something with the court that gives us a legal basis to do something different, okay?
Okay, if I could afford a lawyer, I would get one. I can't. I don't know.
Paige, send her in the chat, send her a phone number for legal aid. And you can reach out to legal aid and they can talk to you about this, okay?
I'll do that right now, Judge.
Okay, thank you. She's gonna send you a number in the chat for legal aid. Why don't you write down that number and call them?
Okay.
All right? Okay, thank you. You're all set for today. Thanks, counsel. Jefferson Capital versus Chandra Hill. Do you have an
Good morning,
opportunity?
John.
Good morning.
Suzanne Strickhardt, P44018 on behalf of the plaintiff.
And did you have an opportunity to speak to Ms. Hill?
Yes, we did. Thank you for allowing us that time, Judge. We're not able to resolve it today. So I think we're just looking for a period of written discovery only.
30 days, 60 days, what do you need?
I think 60 days would be fine, Judge.
60 days will put us at July 12th at 10 o'clock.
Would that be a final pretrial?
It is.
And would any motions be heard on that date, Judge?
If you get it in time, I can hear it then. You can
Okay, but
notice it
doesn't-
for
it's
that
not-
date if you get it on time.
Okay, but it's not necessarily a cutoff if it's not filed at that.
Then we can adjourn it out a month if it's not, if you want to, if the timing doesn't work. Do you understand,
Okay.
Ms. Moody? We're gonna adjourn this. They may file a legal motion on saying why you owe this money.
And I think Ms. Hill's probably looking for a legal aid telephone number as well, Judge.
Okay, Paige, will you send her legal aid's number?
Yes, Miss Hill.
Yes.
Yeah, it's Moody Hill.
Okay, and then Judge Miss Roper, she left before I could even chat her.
Okay. Well, if she reaches out, somebody give her the phone number.
Okay,
Okay.
and Miss Moody Hill, I'm gonna chat you right now with that number.
Yeah,
Can
look in
you
the
explain
chat.
to me before you transfer me wherever? What does that mean when you say that they can file whatever you're saying?
She can file a motion. What she's indicating that she's going to do is perhaps file a motion that says basically under law, for the reasons under law, you owe this money legally, that there isn't a defense to it.
And as far as anything that I can do in regards to that, that would be,
Well, you would have to look at it. I mean, they're going to, I'm trying to pull up hang on just a second. Is this a credit card account?
Yes,
Yeah.
it is. Your Honor.
Okay. That I imagine they're gonna file something that says that, and I'm just guessing at this point, but that they're gonna file something that says you had this credit card, you signed it, you didn't pay the bill, and as a matter of law, you owe the money. Defenses to that are that the account was paid off and you have proof that it was paid off, or somebody illegally opened an account in your name. That's a defense. Those types of things are defenses.
okay.
Do you understand? Or that
Somewhat.
they didn't credit all of your payments. Same thing, you would have to supply proof of the payments that you made that weren't applied to the account. Those types of things.
Okay.
Okay? So it's either a mistake of identity, or the account's been paid, or that the payments were paid and not applied. Those types of things are defenses. I mean, it's not an exclusive list, but I'm just giving you an idea.
Okay.
And Paige, did you chat her?
Yep, I did, Judge. She
Okay,
just has
perfect.
to look in her chat option at the bottom.
All right, Miss Moody, then, and you're all set then.
Okay.
Okay, thank you, Your
Discover
Honor.
Bank versus Terry Shona.
I'm here, Judge.
Hi, good morning, Your Honor. I'm here as well on behalf of the plaintiff, Your Honor.
Good morning. This matter was adjourned to today's date. It looked like you guys were trying to work this out. What's going on?
So, Your Honor, the last I recall is that I believe defendant's debt management company was going to get in touch with our firm.
Okay.
I reviewed our notes and I don't see any information regarding them having contacted us to try to settle the matter. So I think we're pretty much back to where we were last time we were here.
Mr.
Judge,
Shona,
I don't dispute that. I spoke with the company yesterday at some length, and I urged them to proceed with this thing. And I'm a little unhappy with where I am right now.
are you gonna file a motion, Mr. Brainer?
We typically do in such a case.
I'm just trying to figure out if you want me to adjourn it 60 days for you to file a motion.
You know what, Your Honor, if you'd like to, we could do today's written discovery. And then during that time frame, if you'd like to do a cutoff date for dispositive motions, we can do that as well. And that should give defendants some additional time to try and settle it.
All right, I'll give you a date of July the 12th at 10 a.m. And then we can just do the motion cutoff that same day. See if we'll still have to schedule it, but.
For the court's information, I did release some additional dollars to them ahead of time to, I'm anxious to resolve this matter.
No, I figured that you were.
Yeah.
Well, I'll give you that July 12th date. Hopefully you guys have something resolved before then.
Thank you.
Thank you.
Okay, that's July 12th for cutoff and discovery, correct, Your Honor?
Correct. Oh, then do you want me to give you August 23rd date for the motions and the adjourned pretrial?
Sure.
Okay. I'll do a July 12th cutoff date and then an August 23rd at 10 a.m. Adjourned pretrial date. Okay?
Name adjourned pretrial. Okay. And
And we'll do our motions on that day too.
Okay, then motions. All right, Your Honor, before we go off the record, if I could just put out there for defendant's awareness, if you, Mr. Shayneth, if you do decide to proceed outside of your debt management company, we would just need a revocation of the power of attorney. And that'd be something, could be an email in writing to me. If you want to try to settle it on your own, but that's totally up
Well,
to you.
I'm anxious to get this done, but I am not a lawyer. I'm a hell of an engineer, but I don't know much about trials and all this stuff. So I think I will stay with them. I climbed in bed with them. They have a substantial amount of money right now. And I did sign a contract with them. So basically at this point anyway, I think I would have to show some sort of cause other than the fact that they're dragging their feet, or maybe they're not, I don't know. But it seems to me like they are. But look, I think we did discuss this before. When we met, and that is I may not be entirely happy with this process, but I'm not about to abandon them at this point. I don't. It almost looks to me like we all know, or you all know where this is going. I'm not quite sure I do, but it just is going to take a certain amount of time to get through this, I think.
Okay, well, you're all set for today, all right?
Thank you, Judge.
Thank you.
I
Yep,
appreciate
you're
it.
all set.
Thank you, Your Honor.
God bless you.
On asset acceptance versus Wanda White, do I have anybody here on asset? I have you, Miss White. Do I have an attorney on asset
Yes.
acceptance? Yeah.
I'm here on behalf of Asset.
And did you want to break out room with Miss White?
I don't think so, Your Honor. I think we're ready to proceed.
Okay, go ahead.
This is Miss White's motion.
Miss White?
Yes. The jurisdiction, they don't have well, this is what the Michigan compiled law says.
I want you to give me what your objection to the garnishment is. And it's not jurisdiction.
Well, yeah, because they didn't have jurisdiction to get a default judgment in the first place, because the statute of limitation was up on September the 27th. Okay, because they did not, all they did was file the complaint. And so the statute of limitation ran out on September the 27th, 2007. And they didn't serve the, according to the papers, the court papers, they didn't serve the complaint and the summons until between, I think it was November the 19th, and then they had another one. Let me see. It was between, the court record shows between November 19th, 2007 through November the 30th, 2007 is when they served the summons and complaint. And according to the Michigan compiled law, the statute of limitation had already ran out because they didn't serve in time. Then none of this was told. The statute of limitation was not stopped.
On behalf of asset acceptance, do you want to walk me through what your opinion is on the dates on this?
Your Honor, I don't have the proof of service date in front of me due to the age of this account. Obviously, we're showing that the default judgment was entered on January the 10th of 2008.
Right, that's the date I have. That's the date, wait. That's the date that I have, is that the default was, give me the date again. It was
January 10th of 2008 is when the default judgment was entered.
Yeah,
Correct.
that's what I have.
Okay, according to the paperwork that they entered with the court, the last date that shows
I want you to just wait, Miss White. You had your opportunity to speak.
Okay, I will.
Ms. Wait, so we have a default in January of 08.
Correct. So this judgment was later renewed on August the 21st of 2017. And what we note is that even in Ms. White's own motion, she acknowledges a bank garnishment in November of 2013, meaning she was aware, put on notice of this judgment, even if not back in 07, then at least in 2013. And she sat on her rights all the way until now, which is 2021. The court rules do provide, in fairness to the parties, that such motions to challenge a judgment be filed within a reasonable time of the entry of that judgment. And I don't see any argument, either orally or in her motion, that explains how filing a motion to set aside a judgment in 2021 is somehow considered reasonable from a judgment that was entered in 2008 and renewed in 2017. And she never challenged the judgment all of those years, again, reminding the court that she was put on notice of the judgment as early as 2013. So it would be unfair to my client, and it would prejudice my client if, in fact, at this very late stage in the game, Ms. White's motion to challenge the original judgment was granted and the judgment be set aside, particularly due to the age of the account. So obviously, Your Honor, we're asking that due to the untimeliness and the fact that there's no merit, that her motion and objection be denied.
Ms. White, you understand what she's saying is that, and I have that there's a default in the file from January 10th, that they renewed the judgment on August 21st of 2017, and that there was a garnishment, a bank garnishment in November of 2013.
And then even then, I told them that they didn't have jurisdiction, that the court didn't have jurisdiction to even issue the default judgment and the renewal judgment because the statute of limitation was already up on this case. And I also have case law that shows that even over 8 years, because somebody didn't say anything, it's not that I didn't say anything, a lot of the time I was in and out of illness. And
I mean, this was, I take it that this was triggered by a garnishment. Was the garnishment, did you get
the garnishment
anything?
was this year, sometime this year, February, I think.
No, I know. Did you get any money from the garnishment?
We have not to date, and I believe that's because she filed her objection or either it was a moot point. But let me just, Your Honor, really quickly check the account just to confirm that we have not since I last checked.
Yeah.
My apologies, Your Honor. We have in fact received, I'll just note for the court, it looks like we did receive a garnishment payment, $228.25. We received a garnishment payment, $247.50. So yes, we've received some garnishment payments. I had so many cases today. That's why I wanted to double check.
No, it's totally fine. But
to make sure I wasn't confusing it with another case.
Ms. White, the problem is that it's not proper for you to file this motion to set aside a default from a 2008 default case, especially because if you were going to file a motion, it should have been filed in November of 2013 when they did the bank garnishment then. And even then, I don't know what the status would have been, but to come back even 8 years later than that to do a motion to set aside the default, it's not appropriate. The only appropriate motions on your bank garnishment now for objections would be things like that it's Social Security that they're trying to garnish or stuff like that. Do you understand what I'm saying?
But the federal, okay, because they did not fulfill the part of getting this Michigan statute, the statute limitation of Michigan 6 years, because it wasn't told, when they served me, the statute of limitation was already up.
Okay,
It
but
was-
your time to object to that was back then or when you had your bank garnishment in 2013, not 8 years later.
Okay, I gotta
Well,
take,
I'm gonna tell you that I'm gonna rule against you, that I'm gonna deny the motion to set aside, but you can appeal me, okay?
yeah,
And if
I'm gonna
somebody
tell you and I'm
agrees,
gonna
some
sue them.
higher
I'm going to
authority
the
than
federal
me.
court because this
Okay,
is crazy.
that's
Thank you.
fine. All right, thank you.
Thank you, Your Honor.